Hey out there, legal warriors. How do you renew a protection order in Washington State? It got a lot easier if you're the petitioner. It got near impossible to find a renewal if you're a respondent. So if you're interested in the law or either of this applies to you, stay tuned because this is the video for you. My name is Attorney Lance Fryrear, and I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years. And I'm putting out these videos to help educate the public. So if you find it useful, please like and please subscribe. More people get the help they need. I'm just going to jump right into it. We do work in the protection order field for respondents and petitioners. And you may have noticed a video I did a while ago that I called "This is a Disaster." In it, there's a new law that took effect under RCW 7.105 in July, basically 2022, that is a disaster, in my opinion, if you care about fundamental fairness and due process and rights. But it's not a disaster. In fact, it's a miracle if you happen to be on the petitioner side of things requesting a restraining order against somebody. So officially, the law in Washington State, when you get a civil order restricting someone from contacting you or going to certain places, it's called a protection order, but what people in public usually call this a restraining order. So I'm going to jump into this video about the basics of the new law for asking a court to renew a protection order that already exists. So the protection/restraining order, what that means is that somebody has went into court, the petitioner, and asked for an order restraining the respondent from doing certain things. There's domestic violence orders, there's sexual assault orders, there's anti-harassment orders, there's vulnerable adult protection orders, there's stalking orders, all these types of things. And what the legislature did is they moved all those orders into one revised Code of Washington chapter, RCW 7.105. And so now there's a universal way you can ask for an order, but this video is about renewing an order that already exists. And so the statute in question is for renewal now is RCW 7.105.405, and we're going to link to that in the description. And that's a statute that explains that if you are somebody who is the petitioner and you have a protection order against a respondent, even if the order was granted under the old law, and almost all orders right now were under the old law in October 2022 when I'm filming this, you can request to have your order renewed up to 90 days prior to the expiration of your current order. So, you know, if your current order expires on December 1st, 2022, you could start to ask for renewal 3 months before that. September 1st, 2022 is the first day you could ask for a renewal. So how would you ask for a renewal? In other words, you think you still need the order in place to protect you. Well, what you do is you simply get a form online. You would check on the court's website has them, or the Washington court's website has them, and you basically fill out a standardized form that says why you want the order renewed. I want the order renewed because I feel I still need it. You pretty much can put anything down because there's a bunch of negatives in the statute for reasons why the petitioner cannot be denied a renewal. It's pretty crazy. So you're going to go ahead and fill out the reasons why, and then you need to serve that, file it with the court, and then follow the court's procedures about serving the respondent. The court may do it for you, or you might have to have someone do it depending on the type of order you're asking to be renewed. And then the court will set a court date within 14 days of the date that you filed the renewal. Basically, they're supposed to do it within 14 days. So what are the standards? Well, there is no burden of proof on the petitioner to show anything. Nothing needs to be shown except a reason to ask for the renewal. The statute specifically says you don't need to prove that you're still reasonably afraid of the respondent. You just have to ask for it. It says write the reasons, but I can't see any reason you could write where you wouldn't be granted, given what's in the statute, the initial hearing. Write the reason, ask for it, and they're going to set the hearing. So the total burden of proof is on the respondent to show two different things to avoid a renewal of the order. So this is good news if you're the petitioner, right? They have to show what they used to have to show. They have to show, number one, they have to prove by preponderance of the evidence that they're not likely to resume whatever acts that they got found to have done if the order is allowed to expire. So for domestic violence restraining order, they have to show that acts of domestic violence will not reoccur if the order expires. For an anti-harassment order, they have to show that acts of harassment will not happen again if the order is allowed to expire. For a sexual assault protection order, they have to show that acts of sexual assault will not happen again if it's allowed to expire. Same way for stalking, same way for vulnerable adult protection order, you get it. So that was already a very high standard, because it's very difficult for a respondent to prove a negative. And some of the arguments that respondents would use in the past seem to be taken out of available arguments. There's a whole lot of explicit sections that says a request to renew an order should not be denied because, or shall not be denied because, one, the passage of time, two, that there's been no new crimes committed by the restrained party, three, that the restrained party hasn't violated the order, four, that there's other orders available to the petitioner, five, that there's another order that already exists, six, because the protected party took a long time to report it or never reported it. There's all these things that make some logical sense that the respondent can argue that supposedly aren't, at least can't be a sole reason, it's not clear, for the court to deny a renewal. So one, how do you get it renewed? You ask for the stuff. The respondent has to avoid it, has to, one, prove that the wrongful acts won't reoccur. And two, now they also have to show something, a whole new thing in the law called a change in circumstances. The change of circumstances is not strictly defined. There is a list of non-exclusive, unweighted factors that the court can consider in determining whether or not the respondent has shown a change of circumstances. Doesn't make a lot of sense to me because they're pretty repetitive for issue one. It just makes it a lot easier for the court to issue renewal. Well, yeah, you're not likely to reoffend, but two, you haven't shown a change of circumstances. So what are some of the factors that the respondent can show? Well, the respondent can, the things to be considered are, if alcohol or drugs were involved in the case, has that been addressed? Is there evidence of alcohol and drug use still? Well, that's one thing that could work against the respondent. Two, has the respondent taken state certified classes, either for domestic violence in a DV case, for counseling and other types of cases, or has the respondent shown and accepted responsibility? Well, sometimes the respondent can't do that because they don't think they did it to begin with. Sometimes if they accept responsibility, they're opening themselves up to prosecution of a crime. So just think, they may not even be possible for the respondent to show a change in circumstances under the statute. So that's why it's pretty easy to get a renewal. If the respondent has shown suicidal ideation, that also is something there would be no change in circumstances. There's a whole lot of stuff that is working against the respondent. And so what happens? You request the renewal by filling out the form. They set a hearing. The respondent has the same chance to respond like they did in the first hearing, and they'll probably do that in writing. And then you pretty much don't have to do anything. You could file a reply to the response saying about why what they say isn't true and how they haven't done what they're supposed to do under the statute. So read the terms of the statute or have your attorney do so, and it should be very easy to get a renewal. So that's good for petitioners, and it's terrible if you're a respondent who will never get out from under an order if whoever the petitioner is doesn't want you to. The way this law is written, I think it's terrible. That's my opinion. It's atrocious. It's a joke. But from the petitioner's point of view, it's great. So let's hope that it gets used in a proper way. And if you need a renewal, hopefully this video has helped you understand that the bar is very, very, very low to get your order extended. So if you find this video useful, please like and please subscribe. More people get the help they need. And more importantly, If you're on either side of a protection order, a restraining order, you need some help, feel free to give our office a call. We'll do our best. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.